welcome. We're glad that you're here and that you've joined us this afternoon. I begin by acknowledging with gratitude the people who lived and worked in this place where York University is located, the Anishinaabe Nation, the Huron-Wendat, the Haudenosaunee Confederacy, the Métis, and the current treaty holders, the Mississaugas of New Credit First Nation. We acknowledge that when European settlers first came to this land, they entered into a sacred treaty with the Indigenous peoples here, the Truro Wampum, an agreement to peaceably share and care for the Great Lakes region. We acknowledge that this treaty and many others have been and continue to be violated by European and Canadian colonial practices that exploit and spoil the land, the water, the air, and all beings that live here. This meeting is virtual, and because of that, York's land acknowledgement may not represent the territory that you're currently on. So I ask that you each take the responsibility to acknowledge the traditional territory that you are on and its current treaty holders. This is to remind ourselves that we are all treaty people and that whatever we do to the land and to others, we do to ourselves. We seek new ways of being in relationship with Indigenous peoples who are our hosts and with this land where we are guests. So I will also introduce myself very briefly. I'm Luann Good-Gingrich. I'm the director of the Global Labor Research Center, and we're very pleased to be hosting this book launch today and to hear about this important research. A few technical instructions before I pass it over to the panel of speakers. There is live captioning available. You'll see that at the bottom of the Zoom screen. I note that the chat function is not available for audience members. So please put your questions in the Q&A section, also at the bottom of your Zoom screen. And these questions, Leah, I think will read these questions, or one of the panelists will read these questions and direct them to the appropriate panelist for their response. So it's now my great pleasure to introduce you to Professor Leah Vosko, who likely needs no introduction for most of you. Leah is Professor of Political Science and Canada Research Chair in the Political Economy of Gender and Work at York University. Her research, very briefly, focuses on precarious employment, employment standards enforcement, and temporary labor migration. She's the academic research lead on the SSHRC partnership grant, Closing the Enforcement Gap. And today we're celebrating one important contribution from this research, the publication of the collaborative book, Closing the Enforcement Gap, Improving Protections for People in Precarious Jobs. This analysis of a deepening enforcement gap that pervades nearly all aspects of Ontario's employment standards regime is especially timely, as we have so clearly seen in this past year. So we look forward to hearing more about your important work. And Leah, I hand it over to you.
Thank you very much. Thank you, Luann and Hajar, for organizing this event to help us launch our new book, Closing the Enforcement Gap, Improving Employment Standards Protections for People in Precarious Jobs. As Luann mentioned, I'm Leah Vosko and have served as the principal academic investigator alongside the community lead, Mary Gallatley, of the research partnership from which this book originates. And today you'll also hear from a few others involved in the book, including Rebecca Casey from Acadia University, Alan Hall from Memorial, Andrea Nowak from Ryerson, Mark Thomas from York University, and Kieran Mershandani from Ryerson, as well as Eric Tucker from Osgoode. Sorry, Ryerson, sorry, U of T, Kieran, and Eric Tucker from Osgoode. So employment standards, as many people in this audience will know, are legislated minimum conditions of employment in areas such as wages, minimum wages, working time, and vacations and leaves. In Ontario, they are, of course, found in the Employment Standards Act, which together with the Occupational Health and Safety Act is the principal source of workplace protection for employees in the province, especially those in precarious jobs. However, many of the Employment Standards Act's provisions are outdated, aspects of its coverage are spotty, and the inspectorate faces challenges, profound challenges in enforcement, with the effect that many people are poorly protected at work. So our book analyzes and it evaluates the enforcement of employment standards in Ontario in comparative context. It emanates from a multi-year collaborative study involving participants from 17 cross-sectoral partner organizations, including researchers from 7 universities. And Heather, do you think you could move to that slide, please? Thank you. We identify obstacles to effective employment standards enforcement, as well as promising strategies for re-regulation, featuring Ontario-based contributions, as well as contributions from other jurisdictions facing similar challenges, specifically Quebec, Australia, Britain, and the United States. However, our focus here today, and some of the arguments we'll advance, is Ontario. Using the Ontario case, the central claim of the bulk of the book is that while employment standards are a key source of labor protection for many employees, they are not living up to their founding promise to provide a floor of minimum terms and conditions of employment, advancing the principles of fairness and universality, partly as a result of deficiencies in enforcement. Employment standards enforcement strategies are not keeping pace with workplace practices that fuel precarious employment or forms of work for remuneration characterized by dimensions of labor market insecurity. The enforcement gap, we argue, pervades most aspects of the regime, which we will cover today. The reactive individualized complaint system, which does little to prevent violations and remains out of reach of many employees. The under-resourcing of workplace inspections and the limited use of penalties for employers who violate the employment standards. Fueling the enforcement gap are also structural barriers that prevent employees from exercising their voice. Such barriers are shaped by processes of racialization and gendering, as well as divisions based on citizenship and residency status, ableism, and other forms of social differentiation, all of which we argue are exacerbated by power imbalances inherent in the employment relationship. We nevertheless argue that there is nothing inevitable about the enforcement gap. There is no reason why the prevailing state of affairs, leaving many employees poorly protected, is inexorable. So in my remaining time, I'll offer you an overview of the conceptual orientation of the book, a bit of a history of employment standards in Ontario, and key challenges to their enforcement. And then I will speak a little bit about regulatory drivers of the enforcement gap contemporaneously, and I'll conclude by introducing the various ways in which weaknesses in enforcement undermine the promise of employment standard protection, and how we came to apprehend these deficiencies in terms of rights shortfalls, especially through a methodological strategy of active mixing. So in this book, we approach the study of employment standards through the lens of critical political economy, particularly feminist political economy. There's a lot of variation in the political economy literature, but most important for our book is the idea that markets, including labor markets, are not self-regulating. They are socially embedded institutions shaped through the exercise of political and economic power, and shaped fundamentally by social relations of gender, class, race, sexuality, disability, and citizenship, and the contradictions and tensions that they reflect and also engender. We draw in particular on the insights of feminist political economy and political economists studying 20th century developments whose work uncovered the bifurcated and deeply gendered and racialized structure of labor law and policies, and who have linked the inferior floor of labor protections provided by employment standards compared to collective bargaining to the marginalized status of those to whom employment standards were designed initially to apply, namely women and other marginalized groups in the labor market, especially immigrants and people of color, as well as young people. So against this backdrop, our starting point is that employment standards are extremely important to working people, given the direct role they play in shaping the nature of employment. So while the historical dimension of our inquiry is extensive, in the book, we trace the evolution and history of employment standards in Ontario through essentially 10 stages, reflected in the legislative interventions that I list here on this slide. But broadly speaking, we suggest and we trace the early employment standards in Ontario to early Factories Act legislation listed here, which, while they reflect liberal voluntarism in the sense that Fudge and Tucker talk about it, or the idea that legislators' desire is not to interfere in, that was not to interfere in the then nascent industrial capitalist economy, these represent the first time government intervened with protective laws into regulating these social minima that we will talk about today. And in the case of the Factories Act of 1884, we suggest that the interventions meant establishing health and safety standards for all workers in factories, but also standards on limiting the working day applicable only to women and children. And regarding the subsequent Minimum Wage Act, we focus on its exclusion or exemption of social groups presumed to have access to resources beyond the wage, and an assumption that is alive and well today. And against this backdrop, there was a shift to what we talk about as industrial pluralism during and after World War II, a period in which employment standards and the Employment Standards Act was introduced as, and here I quote the archival work that folks did, a collective agreement for the people, forged on the notions of social minima, fairness, and universality. So in this period, the Employment Standards Act was created and the formal emphasis shifted to protecting all employees, but effectively on account of unions' disinterest in these social minima, employment standards became what Fudge speaks of as labor law's little sister. Following the building up of the Employment Standards Act, there was a period of flexibilization between 1995 and 2004, which my colleague here today, Mark Thomas's work shows, and in which many explicit exemptions we find were adopted and the scope of protection of workers were limited. And then we saw, and this marked the beginning of our research time together, the emergence of a series of business-oriented legislative reforms in, for example, the Open for Business Act of 2010, which ushered in a compliance orientation in employment standards and reflected regulatory new governance. And the Stronger Workplaces for a Strong Economy Act of 2014, which in many ways entrenched these reforms. However, shortly after that, we saw a scaling back of some of these reforms through a changing workplace review, which some of you may remember in 2016 and 17, which was followed by short-lived but very far-reaching, largely progressive improvements in the Fair Workplaces, Better Jobs Act. However, on account of the election of the new government in 2018, these were quickly withdrawn under the Making Ontario Open for Business Act. So this is a brief legislative history of employment standards in the province. Now, before speaking about the regulatory drivers, which I want to do, of the enforcement gap that we engage and are reflected in the Open for Business Act, I want to say a few words about a concomitant development which we address in the book, and that is the rise of precarious employment. Time doesn't permit us to cover all the trends that we do in the book. However, what I will say is note that there was a rise and spread of work for remuneration characterized by dimensions of labor market insecurity in Ontario in the period that we cover. Participants will know of the different forms of employment that are often associated with precariousness. These forms grew considerably between 1997 and 2017. And considering dimensions of precariousness more closely, as this slide shows you, fully 74% of all employees in Ontario had no union coverage in 2018, 17% worked in small firms, and 27% earned low wages, and 20% had short job tenure. Furthermore, the same year, and this is my next slide, 27% of employees held precarious jobs defined by three or more dimensions, three of these dimensions or one dimension plus low wages. And global industrial restructuring, we argue, lies partly behind these trends, as the share of Ontario's labor force in manufacturing, previously a highly unionized domain in which we saw standard employment relationships at one point, lies behind these trends. And simultaneously, we saw an increasing share of the provincial labor force come to be employed in service industries, including accommodation and food services, and management, administration, and other services characterized by relatively poor conditions of employment. So many workplaces in Ontario, we would argue, are also being transformed by greater use of contracting out, franchising, and extended supply chains. And this too is a component of what we have been witnessing in Ontario as elsewhere. These ways of structuring work, we suggest, contribute to driving working conditions downwards, while also making the establishment of the traditional parties to an employment relationship, that is, employees and employers, more difficult. At the same time, the adoption of a compliance model of enforcement and of strategies of what we call, borrowing from scholarship, regulatory new governance, are crucial to this picture. So from a political economy perspective, the escalating precariousness that we have seen, and the fissuring, to use a term coined by David Weil, of employment that took place in the last decade can be understood, we feel, as a strategy to maintain or increase profitability as the long post-World War II boom ran out of steam. While firms enjoyed greater freedom to restructure their operations and employment practices, they also sought to contend with government regulations that limited their flexibility, leading them to engage certain forms of reforms to both collective, to push reforms to collective bargaining and employment standards. And so in this context, successive Ontario governments sought to manage these contradictory pressures. And one of the ways they did so was by endorsing a paradigm that is sometimes labeled a new governance paradigm, sometimes labeled regulatory new governance. So broadly speaking, regulatory new governance aims to manage the contradictory demands on government by finding a third way between neoliberal market regulation and traditional regulation, often described as command and control. Prevalent in the field of employment standards, it purports to reconcile the regulatory responsibilities of governments with greater sensitivity to competitive market realities. Approaches to employment standards based on regulatory new governance entail several features. They envision a smaller role for public regulation. They favor a compliance orientation to enforcement. And they assume that violations are the result of ignorance or incompetence, that is, that they are not intentional. And they use soft law tools, rely on soft law tools to affect enforcement. So while regulatory new governance prioritizes compliance in the belief that most employers will become law-abiding, it also recognizes, though, that there are some bad apples and they should be targeted, and because they won't respond to stronger, well-targeted enforcement measures unless enforcement measures are more well-targeted. So these might include modest, proactive, targeted inspections, which you'll hear about shortly, and the use of increasingly punitive sanctions to bring outliers, bad apples, into compliance with their legal obligations. And another central regulatory or feature of regulatory new governance is a promotion of what's called stakeholder participation and engagement. And overall, supporters of regulatory new governance advocate regulated self-regulation, which they argue avoids the pitfalls of, on the one hand, neoliberal market or self-regulation approaches, and on the other hand, traditional top-down enforcement in favor of a third way. So in analyzing regulatory new governance, we find that while this paradigm attempts to reconcile employer demands for flexibility with worker demands for protection, it has a number of flaws, including that it it embraces less adversarial techniques, that insufficiently acknowledge unequal power relations, that it can undermine employees' access to redress when they face violation, and also that it fails to recognize the vulnerability of employees in non-unionized settings. And finally, that it inadvertently incentivizes non-compliance among employers in pursuing the soft type of measures and that I have mentioned and that become knowable. So in the book, and we're only going to talk about part one, it's a rather long book today, our focus, which is our focus in the Ontario part, we look at issues that range from the kind of mapping that I've done so far. We look at the complaint system, we look at complaints administration, wage recovery, the role of workplace inspections, the deterrence gap, and strengthening participatory enforcement. The second part of the book is devoted, as I mentioned, to international or comparative examples, one on Britain, one on Australia, one on Quebec, another one on the US, as well as a sort of summative conclusion. We won't talk about these today, but suffice it to say that what these analyses do is they try to look at Ontario through the experience of other contexts that are shaped by similar regulatory drivers and developments, and to look for prospects for changing the situation. So the analyses in these chapters, I'll just say a couple words about method that comprise part one, which we're talking about today, benefit from an approach, a methodological approach, which is often labeled active mixing and involves taking an interdisciplinary multi-method approach, drawing on qualitative and quantitative analyses, as well as historical, archival, and policy analysis, which the team engaged in, all of which the team engaged in, and to document the multiple drivers of the enforcement gap and their multidimensional effects. In the book, we therefore draw on administrative data. In this case, we look at Ontario's Employment Standards Information System, the large administrative database containing a near census of complaints and information on inspections, to which the Ministry of Labour granted us access through a research agreement, for which we are grateful. And large-scale survey data, so data from StatsCan, interviews and focus groups, which we conducted with 77 low-wage workers, as well as workers' advocates, and 81 members of the Employment Standards Inspectorate and policymakers in Ontario. And finally, but last but definitely not least, extensive archival and contemporary policy research.
So first, I'd like to begin by acknowledging that I'm in Nova Scotia. So I'm in the Mi'kmaq, the ancestral and unceded territory of the Mi'kmaq people. And this territory is covered by the treaties of peace and friendship, and we are all treaty people. So similar to Andy, I'm just going to go over quickly the topics covered in chapter 4 and 5. I can't possibly cover all the details, so I'm just going to go over the key points, and I'm also happy to answer any questions after. During one of the interviews, we talked to a cleaner named Sheila, and she explained how she felt cheated because she never recovered her wages. She said, I haven't been paid. I'm very upset about that part. There's been no penalty. The employer hasn't responded, and she's just letting it go. I'm out of that money. So she feels frustrated that there's no penalty for her employer. So in this chapter, we look at recovery through the complaints process. And so in this chapter, we look at the 3 following areas: voluntary compliance or ordered payment, which is what happens after an ESO determines that a violation has occurred, settlement, and finally, bankruptcy proceedings. There are several challenges for complainants when they seek restitution through all 3 of the mechanisms that I highlighted. When complainants face difficulties in recovering what is owed to them, this erodes a floor of social minima that employment standards are designed to provide. But there are some options that we provide for improving the recovery challenges in Ontario, and I will discuss these in a few slides. So as mentioned earlier, the Employment Standards Act is source of workplace protection for a growing number of employees in Ontario. Unionization has declined, meaning more employees rely on the ESA for workplace protection. There's also a growing proportion of low-wage employees, and we see a greater use of contracting out, franchising, and extended supply chains. And this greater distance may protect employers in high levels of the supply chain from their responsibility of the Employment Standards Act, meaning that they may have greater incentive and less risk to violate employment standards. Since labor costs comprise a considerable portion of total costs for employers, there may be greater incentive to violate the law to decrease the cost of labor. Now, there's been a long history of wage theft. However, there's been very limited attention to wage recovery and the capacity of labor inspectorates to recover back wages for employees. Now, among a few of the studies that have focused on wage recovery, they present some of the strategies adopted by employers to evade payment, such as dissolving their business or transferring assets to other parties. And in the event of formal employer bankruptcy, the lack of effective collection mechanisms available to government officials responsible for employment standards enforcement. Now, together, these result in the non-recovery of wages and thereby erode the minimum conditions. Now I want to move through some of the data that we have using the Ministry of Labor's administrative data. This slide is showing the median total entitlement for complaints with monetary entitlements from 2012-13 to 2014-15. Now, overall, the median total entitlement was $936, a sum that represents over 85 hours of unpaid labor at minimum wage, which does adjust the increase in minimum wage during this time period. Now, there is a difference in size when you compare whether complaints had voluntary compliance or ordered payment. And as you can see in this slide, ordered payments had much larger entitlement sizes. Now, in this slide, we use a logistic regression model to determine whether an employer will be ordered to pay or pay voluntarily. One factor that emerged quite clearly was firm size. In this model, we controlled for employment status, industry entitlement size, and year. Here you can see that 65% of small firms require ordered payment compared to 54% of medium-sized firms and 34% of large firms. This means that medium and large firms pay voluntarily more often than smaller firms, and there's a tendency to require an order to pay, and small firms reflects the existing research that's been mentioned early in this presentation that shows us that small firms tend to be more financially unstable, often undercapitalized. So another factor that emerged was entitlement size, and here we divided the entitlement size into 5 equal-sized quintiles. Now, not surprisingly, we can see here that larger entitlements are much less likely to be paid voluntarily compared to smaller entitlements. Now, I've mentioned that there's these order to pay that get issued. And so the problem with order to pay, as you can see in this slide, is that they rarely get paid in full or even partially paid. So if the employer does not pay, if the employer does not pay voluntarily, you can see that the recovery rates are quite low. And if these orders to pay remain unpaid, they're usually turned over to collections. Now, up until 1998, the Ministry of Labor performed the collections function, and then they outsourced it to private agencies. However, this was not successful. So in 2014, the Ministry of Finance began to undertake collections. Now, it seems promising that the Ministry of Finance will do a better job of collecting unpaid wages, but it was still too early to determine any changes using the data that we had available at the time. Now, shifting over to look at settlements, they're a way to close complaints quickly as they can minimize administrative burden on the Ministry of Labor. So in this slide, we're showing how both non-facilitated and facilitated settlements, which can happen at any time during the complaint process. Now, facilitated settlements occur are facilitated through an employment standards officer and may be appropriate when there's credibility issues, the facts are unclear, or the application of the law is uncertain, or each party's evidence has equal strengths and weaknesses. They're also used more often when there's higher value claims that may be more rigorously contested by the employers. Settlements, and especially facilitated settlements, tend to be much lower than the original total claimed by the complainant. So there is a concern that employees may be under pressure to accept poor settlement. And then we also have to consider that there are some power imbalances between employees and employers. Okay, so now shifting to look at the third piece, which is bankruptcy, there is a need for better protection for employees whose employers become insolvent or bankrupt, and this has been long acknowledged by provincial and federal governments. Up until 2016, in the event of formal bankruptcy, employment standards officers had the option of assisting the complainant in filing a proof of claim. However, from 2009-10 to 2014-15, among complaints where businesses appeared to be bankrupt or insolvent and where monetary entitlements were still owing, the ESIS data suggests that only 7% had a proof of claim filed by the Ministry of Labor, which is quite low. While the WEP is an improvement from what was available to employees before, there are still problems. First, it excludes employers who are in informal insolvency, that is, those who don't formally file for bankruptcy. There's also a 6-month time limit on WEP claims, which means that some former employees may be excluded from receiving compensation. The WEP also prioritizes unpaid wages up to a maximum of $2,000 per employee, which in many cases is just not enough to cover what is owed. There's a need for a wage protection plan run by the Government of Ontario and covers situations of non-payment which are excluded from the WEP, especially for employees in situations of informal bankruptcy. We recommend that employers post a bond or carry some form of insurance. We also recommend making non-payment of orders risky by using liens and license debarment. Another recommendation is to expand the scope of employer liability for orders to pay wages. We recommend making non-payment of orders costly by using liquidated damages for financial hardships and adding interest onto the orders to pay wages. And our final recommendation would be that employment standards officers exercise greater caution when facilitating settlements to make sure that the employees aren't settling for much less than what they're actually owed. Now I want to shift my focus and talk about inspections. In addition to this chapter, there's a new paper out by the group in the Canadian Public Policy, and it kind of expands on what we cover in this chapter as well. Employee-initiated complaints are the foundation for enforcing employment standards. However, this reactive enforcement is inadequate, and there's a need for more proactive strategies, especially if we think about the things that Andy mentioned that go into determining whether or not you should file a complaint. An example of proactive enforcement strategies is to identify sectors or employers where employment standards violations are more prevalent or where workers file complaints. But there's a need for more employment standards officers if this is to be done. And we know that there was a call to have more, and the total number wasn't filled. Now, workplace inspections can offer greater potential to reach larger number of employees, yet in Ontario in 2016, less than 1% of businesses with employees were inspected. Now, there are also some limits to inspections. They do rely heavily on self-regulation and educating employers. There's also this narrow scope of 11 inspectable standards, which typically focus more on, on monetary complaints, and there's very little use of deterrence measure. Now, as you can see from this graph, workplace inspections have played a role in employment standards enforcement, although sometimes a smaller role, but they have started to increase since a decline in 2010-11. Now, as you can see here, we've used 5 main types of workplace inspections, and you can see that expanded investigations became more common throughout the time period, partially at the expense of blitzes, which were not as common in 2015-16. The other note in this to make in this graph is a change in regular inspections, noting the decreased use in 2014-15. Inspections that are both expanded and blitz find the most violations. The lower violation rates found in re-inspection could imply that there are some deterrent effects happening. So this would be when they did an investigation and then went back and did another inspection to see what was happening within the company. Now, there are some limits to the inspections. One is that employers have an advance notice of inspections, which can be good so they can organize their paperwork, but it could allow time to obscure violations. And as I had mentioned earlier, there are 11 standards included in the inspections, and most of these are oriented towards administrative and record keeping practices, as opposed to direct compensation for employees. And we note that unpaid wages is not included in this list of 11, although we know from the complaints data that it is a common violation. While the purpose of inspections is on collective concerns, it is possible that they're missing the violations that are happening. The most common violation is a monetary violation for public holiday pay, followed by the following non-monetary violations: record keeping, hours of work in excess. Now, while inspections occur, it is only in exceptional circumstances and with the permission of the Director of Employment Standards that violations of unpaid wage or termination pay claims can be considered, even though we know that these are common violations based on our complaints data. In this slide, we can see the limited use of deterrence measures in inspections, although noting that they are more commonly used when there's multiple violations and when there are monetary violations. When tickets are used, they're more often used in expanded investigations. Now, in expanded inspections are triggered by a complaint and the ESO has reason to believe that there's more employees affected. So they would go in and look to see what is happening in that workplace. Tickets are also used in re-inspection, although not as often as we see among the expanded investigations. And we note that this is problematic as employers who have a history of violations do not receive harsher punishment when there is another inspection. Now, we offer several recommendations at the end of the chapter, and I'm just going to highlight a few here. There's this assumption that employers' noncompliance is rooted in ignorance, which undermines the efficiency of inspections and ignores the power imbalances that could be happening. Research has also shown that many violations are a strategy for cost reduction. And we really need to see more inspections happening, especially the proactive inspections. There's a need for better enforcement for employers who do not have physical workplaces. And we need to have more effort in addressing fissuring. And so that concludes the topics covered in chapters 4 and 5. And I would like to turn it over now to Alan Hall and Eric Tucker, who will talk about the deterrence gap in more detail. Thank you.
Okay, thank you, Rebecca. Let me share our screen. Okay, so yes, the focus of chapter 6 is to provide an explanation of what we call the deterrence gap, that is the limited use of available deterrence penalties against ES offenders that Rebecca has already begun to discuss. A key question for us is, why did the use of enforcement penalties initially remain limited, even in the context of an apparent government policy emphasis on more enforcement and deterrence? Then we ask, well, why did it ramp up, as you'll see in a moment, during a certain period? And finally, we come back to bringing our discussion up to date by looking at what we characterize as the collapse of deterrence in employment standards enforcement in the period after our study ended. So our study began really when the Liberal government took power in Ontario in 2003 after almost 8 years of Conservative Party rule. The new government publicly asserted a need for more aggressive enforcement of employment standards to protect what they defined as vulnerable workers. Okay. So the Minister of Labor at the time, Chris Bentley, explicitly acknowledged in public statements that there was a greater need for proactive inspections and deterrent measures when responding to ES violations. And in response to this policy initiative, the ministry hired more enforcement officers and expanded its proactive inspection program to include more enforcement blitzes of industries with high rates of violation. As well, a new ticketing system was introduced to offer an additional low-level deterrence measure to the existing notice of contravention penalties and the more serious prosecutions under Part 3 of the Employment Standards of the Provincial Offences Act. However, despite the government's announcements, the ministry's enforcement records indicated there was no meaningful increase in the number of proactive inspections in the following years, nor, you can see that in the blue lines, nor was there a significant or sustained increase in the use of tickets and NOCs, the low-level deterrence measures that could be imposed by inspectors. Similarly, I guess a little bit differently, when we looked at Part 3 prosecutions, there was initially a rise, a modest increase, but then that dropped back more or less to where it had been prior at the time when the Liberals came into power. Arguably, one of the reasons why the ministry failed to deliver on its promise of more inspections and enforcement is because there was a major increase in worker complaints of the sort discussed earlier by Andy, which produced a backlog in investigations. Accordingly, the ministry redirected enforcement resources to clear the backlog. However, once the backlog was eliminated by 2011-12, the ministry reinstated its inspection programs while signaling in public communications that it was again focused on protecting vulnerable workers. It began hiring additional ESOs and adopted what was called the Informed Judgment Matrix, which was a policy tool that was supposed to guide ESOs towards the escalation of their response from education to deterrence measures, depending on the seriousness of the violations and the employer's record of violations. Yet, when we received the next tranche of data covering 2012-2013, we found again that there was no increase in proactive inspections and only a small increase in tickets and NOCs. As well, with Part 3 prosecutions, there was a small increase initially, but then suddenly this unexpected blip in 2014-2015. So apart from that one measure, really the deterrence gap didn't narrow in the years after the government had addressed its backlog. So it was against this background that we were surprised again when we got the next tranche of data, this time covering 2015 to 2018. And here we do see a significant increase in the use of proactive inspections, and even more spectacularly, a very substantial increase in the use of low-level deterrence measures, NOCs and tickets. And as well, the increase that began to take off in Part 3 prosecutions in 2014-15 escalated in 2015-16 and 2016-17, but then again, for some reasons, declined in the last year for which we had data, 2017-18. So in the next part of the presentation, we try to explain these findings and also discuss the changes that have occurred in more recent years. So I'm turning it over to my colleague, Alan Hall.
Thanks, Eric. Let me begin by acknowledging that I'm living in the unceded traditional territory of the Comox First Nation in Vancouver, in BC rather, Vancouver Island. Yeah, as Eric points out, what I want to do here is just briefly, very briefly, provide the line of argument that we developed to try to explain this particular history that he's just outlined. First, we suggested the noises that the government and ministry had been making about vulnerable workers and the need for more enforcement since 2004. They weren't just empty rhetoric. There was actually some substance here. The government understood ES enforcement as an important policy tool for addressing what they saw as increasing problems with inequality and poverty. They viewed those problems as being caused in part by underregulation. So while committed in key ways to neoliberal policies, emphasizing employment flexibility and competitiveness, the Liberal Party was looking for a third way as it came into power. The approach that they hit on is what Leah and others on our team have called regulative new governance. Still nested in an overall neoliberal faith in open markets, individual responsibility, and self-regulation, RNG policy seeks to balance the perceived needs of a free market with the realization that some actors are not playing by the rules, which in turn sets in motion unfair competition pressures on law-abiding employers. Hence the acknowledged need for targeted deterrence without placing undue hardship or restraint on what is assumed to be the majority of law-abiding employers. To achieve this balance, the ministry focuses inspections of what it defines as the high-risk industries, as Rebecca pointed out, largely small businesses such as restaurants, accommodation, personal services, while doubling down on its traditional enforcement mechanisms. That is, while increasing inspections, it seeks to make its claim system more accessible and efficient, largely through online provisions, but also through expanded use of settlements and voluntary compliance efforts and increased educational efforts to seeking to convince employers to abide by the law. In our view, one of the main reasons why the claim shift to more deterrence was limited in the final analysis was that the RNG policy and the ideology and assumptions underlying it still place significant limits on how much deterrence should be applied and on whom, while continuing with the compliance assumptions that education was the most effective tool for gaining corporate cooperation. However, following the work of Lauren Snyder and others, our second line of argument is that the ministry's efforts to change were restrained by a persistence compliance-oriented culture, or what Snyder calls a regulator habitus. That is an historically conditioned disposition among regulators towards accommodation of and sympathy with the corporate actors they are regulating. In the book, we look at both historical evidence and cite our own archival and interview work to demonstrate a past and still active tendency to see enforcement penalties as unnecessary, ineffective, and or harmful, demonstrating as well that there was an active frontline resistance to the call for more deterrence. As one ESO put it, ticketing does not work. I think there's a quota now for part 1, but I don't do it. I'm getting job done without part 1 or part 3 prosecutions. They may be aiming for us to do more, but I feel my focus is on education, not punishment. So we had quite a few ESOs making these kinds of statements. The main thrust of our argument then is that corporate crime, like unemployment standards violations, is under-enforced because regulators with limited power relative to corporate actors are given conflicting goals. That is to prevent violations against relatively powerless workers while still supporting quite powerful business. A compliance-oriented habitus, including a reluctance to treat corporate lawbreakers as culpable, is understood theoretically as a strategic adaptation to the structural conditions of limited power. As such, without major changes in the power relations between ES regulators and employers, ESOs tended to resist policy demands for tougher enforcement. Within this theoretical framework, we only expect to see change in habitus, that is tougher enforcement, if something happens to alter the relative power of the regulators. So our explanation for the lack of enforcement change from 2004 to 2015 is that the ministry did not make sufficient policy and resource changes to convince ESOs and their managers that their power to enforce the law and the rules of the regulative game had really changed. The mixed messages coming from RNG policies calling for more targeted enforcement at the same time that settlements, education, and persuasion were being re-emphasized as critical compliance tools were also important contributors to the persistence of a compliance habitus and the continued lack of enforcement. The lack of restructuring of ESO time allowances and job responsibilities was also key, in the sense that ESOs continued to understand that it was not in their interest to devote too much time to enforcement penalties. But there's still the question of how we understand the more significant reductions that Eric pointed out from 2015 to 2018. What was different? Well, first and foremost, beginning around 2013-14, the ministry began making important changes which we argue at least partially disrupted the compliance habitus. First, they began hiring a significant number of new ESOs using new hiring criteria. Notably, people with enforcement and investigation experience, including some ex-police officers, were hired. These ESOs, as they described themselves to us in interviews, often saw themselves as the cutting edge of a major shift to more deterrence. While most reported strong support from the management, they also viewed themselves as struggling against what they saw as an old compliance culture. Well, we don't know for certain, and we suspect these ESOs were responsible for a good chunk of the increased prosecutions, at least initially. But their actions and approval given by management also likely helped to signal to other ESOs that the rules of the game were actually changing and that they had greater capacity and interest in using deterrence measures. Second, the ministry began a much more systematic training effort encouraging ESOs to use their enforcement tools and the judgment matrix while providing them with more skills. This effort was often supported by local managers who encouraged, guided, and assisted those veteran ESOs who had done very little deterrence work in their careers. Third, the ministry changed the point-based ESO evaluation system, which gave the ESOs both more time to do the enforcement activities and, perhaps more importantly, credited them for the work. And fourth, local managers expressed a greater willingness to defend ESOs against employers who complained about the assessment of penalties, which often happened apparently. In Bardieu's filtering terms, all these measures worked because they empowered ESOs, giving them added human, cultural, social, cultural, and symbolic capital to pursue the ministry's policy of more enforcement. Again, whether intentional or not, prior to these developments, the ministry had done very little to signal to the ESOs that the call for more enforcement was backed by any real shift in their power over the corporate actors or in their own interests as employees of ministry. And as such, they collectively stuck largely to their history of accommodation. There is, of course, one final question we haven't answered. Why did the ministry introduce more substantial policy changes after 2012? This is a little more difficult to answer, as we weren't really allowed to ask senior ministry officials these kinds of questions. In her work on stock market regulation, Snyder argues that periodic crises pointing to widespread corporate wrongdoing, such as the 2008 stock market crash, can weaken corporate actors and push and empower government and regulative agencies to take stronger action. While there was no large-scale crisis of confidence that we can cite in our case, we argue that several developments likely pushed the Ontario government and the ministry further in this direction, including widely publicized releases of research reports on poverty, precarious employment, and continued weak ES enforcement in Ontario law, such as the Law Commission of Ontario's report. Critically, these releases also occurred within the context of elections, partly fought on the issues of poverty and increasing inequality. The Liberal government's loss of majority in the legislature in 2012-14 was also likely critical in pushing the government to present a tougher stance against corporate offenders and the ministry to take more significant steps than they had in the past to disrupt the regulator habitus. Of course, there were still substantial limitations to the reduction in enforcement gap that they accomplished, and whether the ministry under the Liberal government would have continued on the track towards a better enforcement model and outcome is unknown, since as we all know, the Conservative Party got into power soon after the study was completed. We do know, however, that the Conservative, as shown in this slide, that the Conservative government reversed course quite sharply, reinforcing the expressed expectations that many veteran ASOs had expressed to us in their interviews, that they didn't want to make the change to more enforcement because they just expected that it would revert back once a new government came into power. And of course, their predictions came quite true. So our conclusion is that along with identifying the historical origins of a persistent compliance-oriented culture, we've shown that there are both structural and conjunctural, political and economic forces that continue to shape the context within which enforcement takes place, and most notably the challenges associated with regulating the margins of the labor market without undermining profit-driven growth and without provoking political backlashes from segments of capital and labor. We've also demonstrated a complete analysis of the deterrence gap requires that we consider the internal institutional dynamics at the level of enforcement practices, including a persistent compliance culture or habitus, while also recognizing the limitations of central management and government efforts to shape those dynamics, particularly with reference to their efforts to employ an RNG model. And I guess the final point we would just emphasize is that the government, the election of a government certainly reinforces the old adage that governments matter. Thank you. And now I guess I should introduce, we'll move on to Mark and Kieran.
Thank you, Alan. Mark is just sharing the screen, and we're gonna briefly discuss this chapter on participatory approaches to enforcement. So, I guess you know, as many of my colleagues here have talked about, the limits of really the very you know, complaints-driven or current ministry approaches to enforcement, and we wanted to explore in particular participatory approaches to enforcement, particularly focusing on worker centers as participants. And I guess the capacity for you know, these organizations and other similar organizations to create alternatives to individualized complaints-based enforcement mechanisms. And so that was, I guess, the question that we raise in this chapter and try to address in this chapter, right? So as an overview, we start with really trying to review some of the approaches to participatory enforcement. And, you know, what it becomes very clear that while overall enhancing participation is really desirable, the forms of participation can in fact vary a great deal. So, you know, essentially participation can mean many, many things in terms of the actual, you know, power held and, you know, the actual impact within a participatory process. You know, stakeholders in a participatory process can simply be present, while others may in fact have very key decision-making power. So, you know, participation itself does not necessarily lead to better enforcement. It's really the nature of the participation that matters. And that's particularly so in the context of power imbalances, structural inequalities, you know, within contemporary capitalism. So I guess, you know, we wanted to explore, we recognize as we went into this topic that multi-stakeholder processes may not always put stakeholders on equal footing. And in that context, we wanted to explore what is the potential for co-enforcement, which is attentive to power dynamics, attentive to systemic inequalities, which can in fact allow for enhanced enforcement. And we argue really that community organizations, particularly worker centers, are very well placed to be co-enforcers, you know, sort of for, you know, for many reasons, because they, you know, because they are sort of working with workers. They're often in, you know, in relationships and relationships of trust, and they can play a very sort of key role in supporting the work of regulators in better enforcing minimum standards, you know, if they are, I suppose, equal enforcers or equal participants, or, you know, in this particular process. So, you know, that's kind of the focus of our work. You know, how worker centers can support the participation of workers and, you know, enhance, I guess, the enforcement that we have currently, which is so largely based on individual complainants. So Mark will take over and present some of the findings that we had.
Great. Okay. Thanks, Kieran. So we've heard through a number of the other presentations about some of the problems related to the complaints and inspections processes and so on. And we took this as a starting point for this chapter. And as Kieran mentioned, trying to think through and explore ways in which organizations such as worker centers and legal clinics might play a role in addressing some of the real limitations of the existing enforcement practices around complaints and so on. And I'll just, before getting into some of the particular things that we found, just flag a couple of more of the problematic elements of the complaints procedures that workers encounter as they navigate the process of filing complaints and dealing with the Ministry of Labor and so on. On the one hand, employees who experience violations and then raise complaints with the Ministry of Labor, from the perspective of the ministry, are often conceived of and constructed as being empowered to take action against their employers. And what this means is that in a more concrete sense, employees are left on their own as individuals to initiate complaints and to follow the complaints process through. In interviews that our research team had done with workers navigating this process, of course, the experience is not nearly so easily understood as being an experience of empowerment. And there are many aspects of the complaints process that leave individual employees quite vulnerable to various kinds of power dynamics within the workplace vis-a-vis their employers as they initially attempt to broach complaints, and then also in terms of navigating the ministry complaints procedures itself. And so this is where we begin to see a possible role for worker centers and community legal clinics. Thinking of where we start, we have a quote here or a statement from a worker who was engaged in the complaints process and then describes their experience as they worked with the Toronto Workers Action Centre. And in this quote here, we hear, the Workers Action Centre really helped me because they gave me support to fight by saying, you have a right, you can do this, you can do that, you don't have to be afraid. If they didn't advise me, perhaps I might not have been able to do anything. And this just gives a sense in an impressionistic kind of way of some of the very concrete and material supports that workers may receive when working with a worker center or a community legal clinic. And so these were some of the dynamics that we wanted to explore through this research and that we ended up covering in the chapter. Just to get a sense of some further concerns that we noted with the complaints process, employment standards officers themselves will participate as in the complaints process by hearing complaints and of course conducting investigations and so on. And they approach the complaints process through principles of neutral justice and impartiality. In this sense, of course, they're not advocates for workers, but rather they present themselves and they conduct the complaints process and investigations from this position of neutrality. And this in itself can create a limitation from a worker's perspective because it leaves them without an advocate in a sense. In addition, we also, through research or through interviews with employment standards officers, found instances of the presence of ethnic and cultural biases that may inform understandings of the nature of ES violations that may, in fact, lead to targeting of particular sectors in small business communities, and also may lead to misunderstandings of the underlying causes of employment standards violations. And so in both of these senses, on the one hand of providing an advocate for a worker experiencing violations in the workplace, and also for enabling a deeper sense of the understanding of employment standards violations. worker centers and community legal clinics offer some stronger possibilities to address these problems within the complaints process. And we even found that employment standards officers themselves saw an important role for community organizations in providing supports for workers. So now we'll look more concretely at some of the things that we found in terms of the specific roles that worker centers and community legal clinics may play in assisting workers with complaints procedures. On the one hand, there's a role of an education role, where through things like workshops around workers' rights, worker centers can provide important information so that people can understand the legal framework that may offer some protections for them in the workplace. They may offer information lines or phone hotlines, and the general orientation of labor rights education becomes an important piece in contributing to ways in which workers are better able to assert their rights in the workplace. And a representative from the Windsor Workers Education Center explains here, well, I won't read the whole quote, but we can see they're capturing the role that education processes may play in helping to empower workers by generating knowledge about rights in the workplace. A second role that worker centers and community legal clinics may contribute to is in engaging in advocacy. And again, we heard through earlier presentations about other chapters in the book, and this is something we also discuss in our chapter on participatory enforcement, that the individualized nature of the complaints process can be very problematic and can act as a real deterrent for people filing complaints, particularly workers who are in precarious kinds of jobs. And working with community legal clinics and worker centers can be a way of having some assistance in filing claims forms, and also in having an advocate, which can then also provide a way to push back against some of the deeply entrenched power imbalances that are present in many jobs. And a third element of the role, and this is particularly of worker centers, is in not only advocating on the individual level for workers who have complaints, but also engaging in forms of community organizing and advocating in a more collective sense to organize for example, forms of legislative change. And so, in recent years, and this was in particular in the context of as this research project unfolded, there was a great deal of organizing around the campaign, the Fight for $15 and Fairness, which was deeply connected to issues that many workers in precarious jobs face, and that was coordinated, for example, through workers' action centers. So community organizing becomes, though not directly connected to the immediate individual complaints process, becomes a very important role in pushing for the larger legislative change that could make a difference for workplace rights for precarious workers. Now, in the chapter, we also discussed some of the challenges and limitations that worker centers and community legal clinics may run into, and in particular, issues of financial stability and sustainability are very much at the forefront. And so without stable kinds of funding, this can really compromise the long-term capacities of these kinds of centers. And the centers that participated in our study were acknowledging of these kinds of challenges that they face, particularly in some of the smaller communities. I'm going to move to the conclusion here, but just as we wrap up in the chapter, what we try to do is explore some of the avenues that could encourage and support more meaningful kinds of participatory enforcement mechanisms. And some of these things would involve ways that worker centers and community legal clinics could be more formally brought into the complaints and enforcement processes to have more active and formalized kinds of involvement in ways that would then push back against and address some of the limitations of the very individualized kinds of complaints-based mechanisms that are more or less the primary way that workers engage in dealing with problems in the workplace. But at the same time, while we note that in the chapter, as Kieran had mentioned at the beginning, the really important role that community organizations such as worker centers and community legal clinics can play in trying to overcome some of the individualization that occurs and push back against some of the really deep power imbalances, and then help to address this long-standing crisis in employment standards enforcement that really motivated the research project from the beginning, and that runs throughout the chapters of this book. These kinds of centers can play a role in addressing the enforcement gap, but at the same time, this is something that is very much on the periphery of how current enforcement practices really work. And so there's so much to be done to really better integrate and better develop a more participatory approach to employment standards enforcement. And then at the end of the chapter, as we note the very important role that worker centers can play, and the important ways that more participatory forms of enforcement could contribute to addressing the enforcement gap, we also acknowledge that fundamental to the way these organizations work is the need to maintain autonomy. And so that any movement towards more participatory kinds of practices, for example, formalizing relationships in the enforcement process with the Ministry of Labor, also has to, from the outset, ensure the autonomy and the independence of these kinds of organizations, because in the end, it's through independent organizations that workers are going to best, achieve their interests. So I'll stop there and turn things back over to the coordinator of the panel. Thank you.
Hi there, everyone. Thank you so much for the presentations, team. I think we're all very open to questions and comments. As I mentioned at the outset, we have another part to the book, which includes contributions on the UK, Quebec, the United States and Australia, looking at similar developments and also responses to similar developments in the enforcement gap in those jurisdictions. And we encourage you to read those as well. And we thank you for your patience and persistence through this rather long panel. If you have questions, you can share them in the question and answer box and also in the chat. We'd be very keen to hear them, and I can try to field them to whoever is best poised to answer them. I don't see questions at the moment. Luann or Hajar, do you see any?
I don't see any questions at the moment in the Q&A box. People may need a little time to think and integrate their thoughts. I don't know if any of you have questions for one another that may help to prompt some questions from the audience. Just a thought.
Well, I guess I could ask Eric a question, Eric and Alan. I know you've been thinking a fair bit about the recent data around deterrence and penalties and such, thinking about what's happened in the wake of the pandemic. If I don't want to force Alan and Eric to answer this question, but I know you've been thinking about this. If other people have reflections about what the pandemic has revealed about some of the deficiencies that we've seen, I'm sure that the audience members might be interested in your reflections. Anyone want to share some?
Well, what our data showed, at least prior to the pandemic, of course, that it was that under the conservative government, there was virtually an abandonment of the use of deterrence measures. And as Alan, I think, makes clear and our framework makes clear, is that in the absence of very strong leadership from the top to sort of encourage deterrence, the use of deterrence tools, there's a sort of the habitus, the sort of accumulated experience, right, that tends to lead back towards a compliance orientation. How that's played out in employment standards enforcement during the pandemic is not something that I have any insight about. I have a bit more insight about what's happened, of course, in occupational health and safety regulation. And these are just preliminary thoughts because I haven't really done a thorough analysis. And I don't know what's happened in terms of the use of deterrence measures. But generally speaking, the impression I think we get, and maybe Alan can speak to this as well, or all of it, of course, is that the Ministry of Labor, until perhaps recently, when there seems to be a building pressure on them to take some more action against Amazon warehouses, for example, is that they haven't really stepped up to back the concerns that employees have raised. For example, work refusals have almost always resulted that when a worker refuses and it gets to a certain stage, an inspector from the Ministry of Labor shows up, and this, in almost every case when there's been a work refusal, the result of that is that the inspector has not made an order to require the employer to take additional measures for the protection of the health and safety of workers. They've been, I think, very deferential to sort of broad public health guidelines without really sort of using their powers to insist that more protective measures be taken. And so we've seen large workplace outbreaks. I think that is partially the result of that rather lax attitude, is the way I might characterize it.
Thanks, Eric. Alan.
I would just say that I would just add that Eric and I are doing this project now on worker participation, health and safety. Well, actually, in the development of COVID safety plans in both BC and Ontario. And what he says about what's happening in Ontario is also, I mean, again, we're just at early stages of this research, but most of the evidence seems to suggest that the same thing is happening in BC, even though we are actually under an NDP government. The orders are not being pursued in any substantial way, very little in the way of penalties, and work refusals are also are being translated into or transformed into what are essentially complaints rather than what they should be done is pursued as refusals.
Others, Kieran, Becky, Andy, Mark. No other comments about the pandemic? You want to say anything about Nova Scotia, Becky? Rebecca has authored a really great study on employment standard changes in Nova Scotia. I don't know if you have any things to say about that context that you're living in.
Yeah, I thought I did this. It's been almost 2 years, a year and a half, and I thought things were bad in Ontario, but it sounds like, at least from coverage perspective, it's worse in Nova Scotia. But this type of data that we've done in this book isn't available elsewhere, like especially not in Nova Scotia, right? And so people here are kind of excited, especially those working at the Workers' Action Center in Halifax, to think about how maybe other jurisdictions could. I mean, it'd be great if others could get access to the administrative data. I'm sure it won't maybe happen again, but this is like, a gold mine to be able to learn about some of this information that we otherwise wouldn't have known about. So otherwise, just the same, I think, in Nova Scotia, when we're advocating for paid sick days, which is happening across Canada and the world, and then we're just getting a slight increase in minimum wage, trying to advocate obviously for at least 15, but it's actually not as low as it was when I did the report, but it is one of the lowest in Canada.
Thank you very much. Mark, you look like you've turned on your microphone.
Well, yeah, I mean, Rebecca just mentioned paid sick days, and so I guess we'd be remiss to not say something about the fact that there was again no mention of them in the budget in Ontario, or any plans for anything related to this, which, you know, just as in Nova Scotia, it's a major demand, and something related to employment standards, certainly here, though not, you know, directly in the enforcement realm, but the issue of paid sick days is, you know, front and center when it comes to precarious work in the pandemic, and the intersection between these things. And I mean, this is going to continue to be, I think, a major demand and a major issue. And of course, thinking about, you know, our project, were paid sick days to be introduced, that wouldn't bring about an end to the concerns or the problems, of course. And just as we saw with so many of the other elements of employment standards, the fact that even if they were legislated, that would only be one part of the struggle. And I think, you know, one of the things that really comes through in the research in this book is just, we use the term the gap, and just the fact that addressing the difference between what the law says and what workers actually experience is going to remain a major problem. And thinking through, you know, it's really interesting to hear some examples from the other countries that are represented in the book as well, just to hear what other places are doing. But at the same time, there are many common problems. And so the struggle for paid sick days, just to bring it back to that, I guess, is an important one. But even if we were to see those legislated, you know, it wouldn't end there.
Yes, clearly the pandemic has exacerbated the gap. And I know in some of my own work around labor inspection in farm workplaces and other types of inspection, you see it really boldly in some of the occupations that we document to be so highly precarious and inadequately covered by workplace inspections, like Rebecca and Eric and I find in a study of agricultural workplaces in Ontario. All right, then. Thank you so much. I assume, Andy, you don't want to have the last word. If you do, you are welcome. And Kieran, too. I don't know, Kieran, if you're here anymore, as I cannot see your face. But if either of you want to have a word, please let me know. Oh, well, thank you all for enduring with us in this Zoom endurance test, hearing about the first part of our book, Closing the Enforcement Gap, Improving Protections for People in Precarious Jobs. And thank you so much to the Global Labor Research Center and all the panelists for hosting this event. We urge you to read the book and tell us what you think. Reach out to us if you have further questions or comments. Otherwise, I think we say goodbye.